say that again. So the 5G rollout is underway en masse. The major players in the rollout are really site developers, not the carriers themselves, because right now in the 5G rollout, the majority of the infrastructure being built are small cells and DOS systems, which are being built by site development companies who simply make money building infrastructure and leasing space to the carriers. There's a major battle going on before local governments across the entire country, because the site developers are trying to put these things pretty much everywhere they want. In major cities, they want to put them roughly every 300 feet. Ahead of that major rollout, there was a major spread of misinformation. People are being led to believe, and I hear this every day, that local governments' hands are tied, that local governments, planning boards, zoning boards have no power to control the placement of these wireless facilities. And that is, quite frankly, false. What I spend all day telling people, and local governments who call me every single day from all over the country, when the Telecommunications Act of 1996 was enacted, Congress preserved to local governments the general authority to regulate the placement of wireless facilities. That has never changed. Local governments have available to them the power to control where these things go. However, the second main paragraph of the Telecommunications Act does place upon them 5, what I would call mainly procedural restrictions, where there's certain procedures local governments have to follow when they're entertaining applications for wireless facilities. Every day, people are calling me and saying, I woke up and there's a small cell 8 feet outside my daughter's bedroom window. What the heck's going on? And I always tell them the same thing. There's only one of two reasons that happens. Number one, either your local government hasn't updated their code to give the local boards the power to stop this, or the wireless industry has gotten to your state legislature to adopt a state law which strips them of that power. Either way, there's plenty you can do. There are many ways to defeat these applications. Since 1996, local governments, sophisticated local governments, have been using their zoning power to enforce smart planning provisions. And what does that mean? Well, look, everybody loves their smartphone, everybody loves their iPad. And with the current technology, you need some form of wireless facilities where those things don't work. So theoretically, cell towers are a necessary evil. But it's just like sewage treatment plants. Just because they're necessary, it doesn't mean you put it right next to somebody's house. So smart planning provisions are designed to enable carriers to give you coverage, while number one, minimizing the number of facilities you need to provide that coverage, and number two, avoiding to the greatest extent possible any adverse, unnecessary impacts on individual homes and communities. And again, you can do this so long as you enact your code to do that. Up against that, however, you have site developers. If they can cover your town with 3 cell towers or 5, they'd rather do 5 because they get paid for every tower that goes up month after month forever. So this is the battle that's going on. Well, Crown Castle and Extenet are big ones. They're big companies. They're very smart. They have very good attorneys. And they are aggressively, I deal with them all the time, constantly. People hire me because they say, you know, one of these site developers, whatever name they may be, they want to put this thing literally 20 feet outside my daughter's bedroom window. And they're telling my local government that federal law says you can't do it. And that's a lie. And so right now, when people hire us before a public hearing closes and we accept the case, we typically stop them right around 75, 80% of the time. So we're pretty good. Well, that's exactly what Congress wrote into the Telecommunications Act. The very first paragraph says the power to control the placement of wireless facilities is preserved to state and local governments, except as otherwise provided herein. So the general rule remains, as it has since 1996. Local governments have the general power to control the placement of wireless facilities. The misinformation is that the wireless industry is telling attorneys, regular municipal attorneys who really don't understand the Telecommunications Act, that their hands are tied, and they believe it. And it's mind-blowing every day when I hear this and I see what happens. Similarly, they're not aware. Local planning boards have no idea, for example, if an applicant comes in and says, we have a significant gap in wireless service, this proposed tower is the least intrusive means to remedy that gap, and therefore, local law requires you to allow us to do it. Well, if they can prove those two things, then perhaps federal law would say that denying their application would be what's called an effective prohibition. But who gets to say if there's a significant gap in service? Not the carrier, not the site developer. That's up to the planning board or the zoning board. But most local boards give them no guidance. They don't know how to make that determination. They don't know what type of evidence to ask for. And I'll tell you this, in 90% of the cases I see, applicants are submitting false information and tricking local zoning boards. And then when they walk out, they laugh about how gullible the local board members were. And it's certainly enacting code revisions which provide guidance to your local boards so they know exactly what they need to do. Guidance to let them, for example, recognize when someone submits a false FCC compliance report. It's easy to spot if you know what to look for, but when the average planning board member sees an FCC compliance report, it might as well be written in Latin. They have no idea what they're looking at.
Exactly.
It's easy to see when they're false. It's easy. The other thing they should really remain cognizant of is stay involved and stay in contact with the state legislatures, because the wireless industry is really exerting tremendous influence to get states to strip local governments of their power to control these things. The reality is local governments are in the best position to enforce smart planning provisions. You know, I've seen cases where I'm dealing with a small town somewhere in the Midwest or down south, and they can easily cover the entire town with 3 cell towers and put one out in the woods and one in a landfill and one in a junkyard. But the wireless industry doesn't want to do that, because if they put it in the woods, it costs them more money. They want to put it in the center of town. And they want to put a 150-foot tower 25 feet from a 2-story house. There's no reason for that other than they want to have less expense when they're putting the tower up. And unless your local government enacts ordinances to control against that, it's going to happen. It's happening every day. So local governments should amend their codes, and they should get on the horn with the state ledge and say, don't even think about adopting one of these laws to take our power away. We know our town. We know the history. We know the zoning districts. That's the whole purpose we set up zoning districts, is to prevent incompatible uses of property from being right next to each other. You don't put a sewage treatment plant right next to grandma's house. You plan in an intelligent way. And the state laws strip that power away from local governments, and it should never, ever happen.
And do they see 5G as another way of getting around it, like as opposed to the one larger tower? Well, it's just a small box, right? They don't view it quite the same way.
Yeah, I'm sorry. From a financial perspective, the problem with 5G is it's a major cash cow for the site developers. Site developers, every time they build a wireless facility, it's a money generator. They get paid rent month after month after they build it forever. So if you put up 3 facilities, they're going to get paid three payments a month for the rest of forever. But instead, if they go into a local neighborhood, as they've done in affluent villages here on Long Island, and they put a small cell or a DOS node every 300 feet, they're going to get paid once they go up for every single one they put up. The financial revenue is endless. It's an endless stream. So they want to put up as many as possible, as fast as possible. They're actually racing with each other. They're trying to get as many up as they possibly can before local governments wise up and amend their codes.
Is that the same company, though, as the wireless companies themselves? Because I would think the wireless, the main infrastructure providers, I don't want to say any particular names, would want to have as few points as possible. From their perspective, it's or do they are they also profiting from having more installations via some, I don't know, some government bill?
Okay. Well, here's the distinction between the two first. Okay. First, you have your wireless carriers. Mm-hmm. They're companies like Verizon, AT&T. These are companies you can actually get your cell phone service with.
Yep.
Site developers are companies that don't provide any personal wireless services.
Mm-hmm.
They build and own infrastructure and lease space on the infrastructure to somebody else. Now, to the extent that local governments have any smart planning provisions, once somebody builds a facility, the next company that wants to come in is supposed to try to co-locate or use their facility. Now, if a site developer builds a DOS node system, they come into your neighborhood, they put DOS nodes. One system might have 50 DOS nodes, and they put them every 300 feet in your neighborhood. If now Verizon comes in and wants to roll out 4G or 5G in that area, the easiest thing to do is just go through the site developer, because the infrastructure is built, and the local government's going to say, why would we give you an approval for a new tower? There's already infrastructure there. Why can't you co-locate on an existing tower or use the capacity on this DOS node system? So the first one in wins. And the same thing with cell towers. If a company comes in and builds a 150-foot cell tower that can accommodate 3 carriers, they win. They can get their competitors, they can force their competitors to lease space on their tower. So AT&T can kind of force Verizon and vice versa.
So just like you said, we have to go and help these towns. That was Dalton Gardens, Idaho calling me. And as soon as I get off of this, I'm going to appear there to try to get a wireless ordinance because they're 2.4 square miles between Coeur d'Alene and Hayden, and they don't have a wireless ordinance. They don't even have a cell tower yet. But like you want, Crown Castle's coming in and saying we want to put it in front of every house, and we're trying to protect them. So we're doing the best we can to be foot soldiers for what you teach, Andrew.
And with only 2,000 or so citizens, naturally, or residents, they're not going to have, most likely, a cell tower expert, a subject matter expert to know how to best guide the town. And there's 35,000 or so communities, 40,000 within the United States. So they are going to fall a victim to what they believe is true.
Yeah, and if we could just clone Andrew, that would certainly help the world. But as many people that can get to him, he helps them.
Well, Mark, that makes me think.
Cloning's another issue.
When you talk about a town with 2,000 people, that leads me to one more piece of information that's very critical to share. Please. Very often, if an applicant comes in and files an application to build a wireless facility, and they get the sense that the planning board or ZBA is going to turn it down, they basically either suggest or openly threaten, well, if you turn us down, we're going to drag you into federal court. And local governments all the time are afraid and said, oh my God, this developer or carrier, they're going to bankrupt the town. Nothing could be further from the truth. And here's why. If the local government violates the Telecommunications Act and gets sued in federal court and loses, the local government does not have to pay a penny in attorney's fees. The United States Supreme Court has ruled that when a site developer or carrier prevails, they cannot recover their attorney's fees under the Telecommunications Act. They also normally don't get damages. The relief they get is a court order telling them you have to let the tower go up. So any thought that, oh my God, Verizon or AT&T or somebody is going to bankrupt the town, it's never going to happen. It's a hollow threat. Don't be afraid.
Yeah, it's just a bunch of saber rattling, just trying to get you to go along. It's a lot of bullying. All right. Listen, Andrew, we know you're so busy. We really appreciate you staying a little late tonight and giving us some of this great information. But what's the website they should visit?
Well, right now they can visit campenellipc.com. That's my law firm's website. For local governments, I take calls. I give some free advice, but ordinance reviews take a lot of time, and I can explain exactly what's involved. And if someone wants to stop the irresponsible placement of a cell tower very close to their home, if it's a case we'll take, again, we typically stop them 75, 80% of the time. I can't guarantee we win every time, but we're pretty good. So listen, I thank you so much for inviting me.